Distinguished guests, speaker, and fellow participants, good evening to you all. As we are about to commence our session, I kindly request everyone to settle in and ensure your connection is stable. Before we begin, I would like to remind all of the participants the ground rules for today's discussion. First of all, be punctual. Please join the meeting on time and ensure you remain connected during the session. Second of all, dress appropriately. Even though it's an online meeting, participants are encouraged to dress appropriately, maintaining a professional appearance throughout the session. Third of all, minimize distractions. Please find a quiet, well-lit space for the meeting and minimize background noise and distractions. Mute notifications on your devices to avoid interruptions. Fourth of all, participate actively. We invite an active participation. Please engage in a discussion, contribute your ideas, and listen attentively to others. Should you wish to contribute or pose a question, please utilize the raise hand feature or submit your inquiries through the chat box. 5. Respect others' speaking time. To maintain order, please refrain from interrupting any speaker. All questions will be addressed during the designated Q&A session. Sixth of all, use neutral language and tone. Please maintain a neutral demeanor in your language and tone and avoid using slang or inappropriate language. Seventh of all, be mindful of camera etiquette. Keep your camera on unless there's a valid reason to turn it off. Maintain proper posture and avoid distracting movements or gestures. Furthermore, to maintain our administrative records, the link for the attendance form will be posted in the chat box shortly. We encourage all participants to complete the form to ensure your presence is officially documented. All right, without any further ado, Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh, Shalom, Namo Buddhaya, may peace be upon us. I am thrilled to welcome all of you to our monthly discussions on global legal affairs. This event is brought to you by the Udayana Research Center for International Law and the Student Community for International Law from the Faculty of Law, Udayana University. My name is Belle, and I'll be your MC for today's session. Before we proceed, let us extend our deepest gratitude and a warm welcome to our distinguished guest who has graced us with their presence. Dr. Imade Budi Arsika, SH-LLM, as the head of International Law Department, and our esteemed facilitator, Dr. Cokorda Istri Diah Widyantari Pradnyadewi, SH-MH. We're here to discuss an issue of international law today with the title, Redefining State Responsibility for Submarine Communication Cable Destruction in Modern Warfare. Today, nearly 97% of global data, from nuclear command codes to trillion-dollar financial transactions, flow through submarine communication cables, or SCCs, no thicker than a garden hose. Yet, despite forming the backbone of global digital system, these cables remain a legal gray area in modern warfare. Recent disruptions in the Baltic Sea between 2021 and 2025 demonstrate how damage to these cables can paralyze national economies without a single shot being fired. Against this backdrop, this research examines the legal tension between the peacetime regime of UNCLOS 1982 and the wartime framework of the 1907 Hague Convention IV, revealing the gaps in the current lex lata concerning state responsibility under RCWA framework. More fundamentally, it questions whether SCCs, given their dual-use nature, should be considered protected civilian objects or lawful military targets under international humanitarian law, and how the vague notion of absolute necessity might be clarified in determining legitimate targets in modern conflict. To lead us through this inquiry, we are joined by our speaker, Ms. Carmelita Vondrawijaya, a student of Faculty of Law, Udayana University. Before we move with today's event, I would like to call upon Dr. Imade Budi Arsika, SH-LLM, to deliver his opening address. The time and place is yours.
Thank you very much, the MC, Belinda. Am I audible?
Yes.
Yep. Thank you very much. Uh, so, good evening, everyone. Your Excellency, Professor Igusti Ngurah Parikesit Widyateja, the initiator, founder of Udayana Research Center for International Law and Policy, the UNCIL, a research group at the Faculty of Udayana University. Also, I see the professors and lecturer of International Law Department of the Faculty of Law Udayana University. I think hopefully already joined Professor Dr. Idewegede Palguna because he's also the supervisor of Pondra for this bachelor thesis. And also Ibu Dr. Chok Istri Diah Widyantari Pratnya Dewi, who will act as a facilitator or moderator today. Also, I think we have already here also Ana Agung Savita Beauty Anaya, the president of ACIL, and other ACIL executive board members. Today, I was assigned by Dr. Made Suksma Prijandini Devi Salain, the coordinator of Bachelor of Law Study Program, to deliver opening remarks on this occasion. It is our pleasure because we could organize again the international law today, the monthly discussions on global legal affairs. It is a co-curricular program which is jointly organized by the International Law Department and Student Community for International Law. I think I'd like to repeat again that the UNCIL has initiated this program since last year, which regularly presented the most talented student who carry out research on the topic of international law, which becoming part of his or her bachelor thesis. So the idea is we should disseminate, we should publicize, we should socialize the knowledge and research results by these talented students. The advantage in the context of the transfer of knowledge, I think this program can always make an update issue. I mean, what is ongoing topic, hot debates in the context of the international law. So we can, okay, now we understand the ongoing issues and we can look at the relevant principles, norms, theory, as well as the legal concept to analyze them. And I do appreciate Carmelita Fondra Wijaya, the speaker today. Yeah, I was acting as the co-supervisor because the first supervisors was Professor Idewo Palguna. So we work together. Actually, this is her work. I mean, we accompany and we discuss during the supervising process. And yes, I think the basic concept of international law has already been deeply discussed in the topic of the submarine communication cable destructions. And everyone, I think everybody aware the ongoing warfare in several parts of the world, let's say in the Middle East, in Ukraine, Russia, and other parts of the world. and the modern warfare is at stake. And Carmelita Fondra Wijaya, we usually call her Fondra, she interested in conducting a research focusing on the submarine cable. Fondra, it is our honor because you will present the result of research. And I would like to express my thankfulness to all committee for preparing this event. On behalf of the coordinator of Bachelor of Law study program, I finally declare that the co-curricular programs International Law Today, monthly discussion on global legal affairs, with the topic redefining state responsibility for submarine communication cable destructions in modern warfare, is officially open. Thank you very much.
Okay, thank you very much to Mr. Budi Arsika for the wonderful remarks. And the moment you've all been waiting for, all distinguished participants, I'm excited to introduce our speaker, Ms. Carmelita Fondra Wijaya, a student of Faculty of Law Udayana University. Her research explores the growing legal challenges surrounding the destruction of submarine communication cables in modern warfare, examining the tension between UNCLOS 1982 and the 1907 Hague Convention IV, and questioning how international law should redefine state responsibility in the face of this emerging threat. Also, to help us navigate with our discussions, please welcome our facilitator, Dr. Cokorda Istri Diah Widyantari Pratnyadewi, SH.MH. To Ibu Cak Diah, the time is yours.
Thank you. Thank you, Belinda. Good evening for everyone. Swastiastu. It's honor to me to be facilitator for today's event. But before we move on to Fondra to deliver her presentation, let me greeting the Honorable Head of International Law Department, Bapak Dr. Imadi Budi Arsika, SHLLM, that already giving us opening remark for today's event, and also the initiator and the founder of Udayana Research Center for International Law, Bapak Profesor Parikesit. Thank you very much. And also the supervisor of Fondra and Bapak Profesor Dr. Idewa Gede Palguna SH.MH. Thank you very much. And the lecturer and from or professor from International Law Department present today, and of course SEAL and committee that prepared this event, and all participants. Thank you very much for joining today's event. I hope we will have a very fruitful discussion from today's. And of course, Fondra will deliver her presentation about redefining state responsibility for submarine communication destruction in modern warfare. Submarine communication system, especially submarine cables that carry global internet data traffic, have become a critical infrastructure. Traditionally, international law such as UNCLOS or any other instrument are recognize the importance of protecting submarine cables and obligates a state to avoid intentional damage to them. However, modern conflict increasingly involve hybrid warfare, cyber operations, and covert naval activities that can disrupt this underwater communication network. This situation raises questions about how state responsibilities should be interpreted and applied. Considering today's situation, maybe will be discussed later after Fondra deliver her presentation. So, is international law still relevant? Okay, Fondra, without further ado, you may proceed your presentation.
Thank you very much, Ibu Jo, for the introduction. First of all, good evening, ladies and gentlemen. Good evening as well to the honorable lecturers, Bapak Profesor Sigit, Bapak Dr. Ima Budiarsika, and of course, Ibu Jokordadia Istri Winyantari Pratnyadewi. Thank you very much for this wonderful opportunities, and I would like to thank you for handling this event as well to my juniors in SCIL. But first of all, I would like to ask for permission to share my screen, Ibu Jok, if that's okay.
You may.
Thank you, Ibu Jok.
Yes.
All right, so it is an honor for me to be here with all of you guys. Maybe you have time to do, but you're making time here for for this event. So thank you very much for your attendance, first of all. What I'm going to deliver to you and share to you today is about my thesis. Well, the title is The State Responsibility for the Destruction of Submarine Cable Communication Systems from the Perspective of International Humanitarian Law. So from the title itself, we can see that there are three elements here. So first of all, it's about state responsibility. The second one is about the submarine cable communication system. Hereinafter, I will mention it as the SCC. And the third one, of course, the international humanitarian law. When we talk about international humanitarian law, of course, we're talking about laws, and we're talking about the war itself. The war itself is actually it's not a good thing. It's about chaos, and it's about everything that happening in this world that you can imagine. However, the law itself is intended to press the damage down from the war itself. So let's move on to the introduction. If I were to ask what is the urgency of this research, first of all, I want you guys to imagine you wake up in the morning, you're going to call your mom, you talk to your mother, and then you check your friends through the Instagram stories, what they have been doing, right? And you go to Netflix, you check your favorite last season. Maybe it's Wednesday, maybe it's Dynasty. Anyone here is watching that? But what does it particularly connects with the internet, actually? Well, in fact, the SCC itself is a backbone of the internet. Without it, you cannot access the internet. You cannot go to talk to your mother, which is not in the same island, and you cannot even watch Netflix. Well, it happens because at war, the SEC itself is the main target of the military necessity. And 95%, in fact, of the telephone and internet communications around the world every day, which moving and the data itself has moved through the SEC. So that's why it became very urgent. And not to mention that there are a lot of phenomena happening in the Baltic Sea, namely that I could remember is that the 2024 the Finland Christmas Day cable cutting, which is kind of surprising because it is when on the Christmas Day, and it is done by the Eagle S. So the Eagle S was a Russian ghost fleet. what is Ghost Fleet? So Ghost Fleet is basically an old tanker that carries oil. And in that time, Russia was being sanctioned. Russia was being embargoed because they went to war with Ukraine, right? And this fleet or this ship was not registered at all. And surprisingly, they have the anchor, right? They have the anchor, and they move their anchor to 90 kilometers long, and it cuts the subsea communication cable. So that's why at that time, the Finland people could not use the internet. It's just purely blackout. They don't have any entertainment, and yeah, it's that bad. From the historical case itself, we're talking about the Cuba Submarine Telegraph Code, which involved the Great Britain versus United States, which is happening in 1923, over a century ago. But it is, however, it is still irrelevant to our issues today, because this is a classical issue which has been happening over and over again, decades after decades. So, to make it clear about the urgency, when those experience in the Baltic Sea shows that that is actually a phenomenon that could lead to war. And we can also mention that in these days, such warfare are not involving man to man, and they're not involving like sending humans into the war itself, but they are using a better technology. They are using a more lethal weapons that we cannot even think about, because if you can see, our president, Mr. Prabowo Subianto, actually mentions that our budget, our state budget, is conditioned to fund our defense mechanism. So this is why we could note that actually advancement in technology and the existence of the anonymous underwater vehicle, and also the sabotage technology, plus the geopolitical instability. As you can see, the world today is very fragile. The world is today, as you can see, that the Hormuz Sea is now closed, that the fuels are going up. We cannot even think about the possibilities, the worst case possible. And it creates a very great urgency for this research to be discussed. So I was thinking about, what if the situation is going to be more fatal, where our objects feel permissible to attack? Because I was conversing with one of the military officials in Indonesia. At that time, I were interning in the Ministry of Political and Security Affairs, and he said that when war happens, it is very normal to destroy everything. So as you can see, it's halal to destroy everything, and it makes me think that, does international really exist? But that will be the question, as Buchok has mentioned it before, right? So, as I have mentioned before, the SEC has become the main target on military engagement, and the further question exists. This is a legal question. When we are questioning about the SEC, whether is it a military objective or is it actually a civilian object? Therefore, I presented you my two research questions. So first of all, what are the provisions regarding the accountability of states that commit acts of destruction of SKKL or SEC under international law, particularly international humanitarian law? And second, what regulatory model can be applied to acts of destruction of SEC in situation of international armed conflict? The scope of problems will be simple. I will be, from the first question, I will be talking about the Lex Lata, or you can call it the current law, the current positive law that is governing it. And the second one is the Lex Ferenda, or the what the law is out, or what it should be. This is my research objectives, from the theoretical to practical. And I will mention the theoretical basis from this research as well, because I mentioned that the first element is the state responsibility in IHL. The question then arises, does failure on the IHL adherence also triggers RCWA, or you can see the articles under the responsibility of states for internationally wrongful act? Because this document exists in 2001, made by the ILC. And does it also trigger the Vienna Convention on the Law of Treaties in 1969? Because when we are talking about the international humanitarian law, we are also talking about the treaties itself that governs the war itself. So in Article 2 of RCWA, we can find that actually the elements of internationally wrongful act of a state consist of, first, is attributable to the state under international law, meaning that it should be connected to the state. And second, it should constitute a breach of international obligation of the states, meaning that there should be a law that is actually being violated. There's an international obligation that is being violated. So, referring to the first question itself, does the failure on the IHL adherence triggers that? The question will be yes. The answer to the question will be yes. Because when the treaty itself being violated, it also causes the restitution, the rehabilitation, and compensation, and also satisfaction as the act of repair as a part of that state responsibility. All right, another theoretical basis that I also brought to this thesis is that I used the principle of distinction from the additional protocol itself. So the additional protocol itself is that the obligation that I've been mentioning before, that it emphasized that only direct armed attacks against combatants and military objectives are legitimate. So what does that, what can we infer from that? When a state attack an SEC, that would violate the Article 57 2B of the additional protocol, and therefore it is a legitimate attack, and we can distinguish it. We can differentiate the attack from a state wrongdoings, namely towards a military objective and also a civilian objective. So the principle of distinction here emphasizes that actually why does it matter? Why does it matter why we cannot attack a civilian object? Because what the obligation carries is that it is only justifiable. It is only justifiable to attack a military object. And this is what I've been thinking about, namely when I see the laws itself, because you can see here I am writing the primary legal materials, namely the regulations to Hague Convention IV, which is also over a century, 1907, and this is 2026. I was referring as well to the United Nations, the UNCLOS in 1982, and also the oldest one, sadly, the Convention on the Protection of Submarine Telegraph Cable. I was questioning, are these still relevant in 2026? In the chapter 2, I was talking about what is Submarine Cable Communication System, or the SCC, and also I was trying to understand, and I was trying to dig deeper to what is war, because actually the war that we understand right now is actually an international armed conflict. There's no war well, we can talk about it later, because war itself, because it can be differed to the war that happened between nations and the war that happened inside of the nations itself. It's gonna be interesting. First of all, regarding this communication cable system, or the SCC, you can see here, I analyze it grammatically, and there are some definition from ICPC and also the Tallinn Manual. This is a fun fact actually. Tallinn Manual 2.0, it's not a convention, it's not a hard law, it's a soft law, and it is actually governing the states. Like it shows the conduct of war, but it is conducted in cyberspace. So it's not a physical war. It's not the conventional war as you can see in, maybe some of you watch about Hacksaw Ridge, or maybe some of you also watch 1913, which is, I like that film. The warfare itself today is very different from then. So this is why I'm trying to dig deeper into this topic, and this is what makes it more interesting. I also divided the lex lata during peacetime and during international armed conflict, which is in peacetime, the UNCLOS, the UNCLOS 1982 applies, and also the Cable Convention 1884 also applies. It is much different from the law itself that applies in international armed conflict or in war. Namely, we can see the regulations annexed to Hague Convention IV. And also this.
Dari mana? Dari dosen? Iya, begini. Keluar langsung apa?
So this is the map. This is the map that I've been researching. I talked to one of the military officers in Indonesia, namely from Pushidrosal or Pusat Hidrologi Oceanografi, TNI AL. So they are dealing with everything happens in the sea, apparently. So the warfare as well. In Indonesia, there are a total of 301 submarine cable routes. They were mentioning that 27 of them are international routes and 274 of them are domestic. So we also have the cross-ministerial and interagency coordination under the National Team for the Pipeline and Cable Agreement. And it's almost the same with other states that I've been researching on, because I took one state from one continent. So we have 5 continents here: Ireland from Europe, Egypt from Africa, Singapore, Asia, Indonesia, and USA, of course. They have also their own agency to deal with this cable. And what does it do with international armed conflict? So as I said before, there are 2 types of international armed conflict. The first one is international armed conflict, as we understand that when 2 states are involved in the war. And what makes it different from the elements itself, you can see it right here. And Pietro Ferri, of course, in 1992, have defined that international armed conflict is a general expression referring to confrontations involving 2 or more states, a state or non-state entity, and a state and insurgent groups, or 2 ethnic groups within a state. In chapter 3, I was trying to answer the research questions. The first research question, it's about what is the law and how does it governs the SEC in the midst of international armed conflict. And in a time of peace, as I said before, that we actually recognize this Article 2, Paragraph 4, in which the United Nations itself in 1945 actually emphasized that all members shall refrain in their international relations from the threat of the use of force. So this is basically a prohibition for states to using their force. What is the force? Well, to use the military force, to use the attacks, the direct physical or maybe cyber attacks to threat another states, because, well, it is relevant to the principle of sovereignty. And in Article 51, it talks about the self-defense, but we will talk about it later as well. There's also Cable Convention 1884 that is actually bringing the basic of the law itself that governs the SEC. So, well, it is an international offense. It is an obligation to not to break the cables, to not to destroy the cables, because there is a big urgency right here. When the cables itself, at that time, it was a telegraph cable. It's not submarine communications cable like today, but it still matters because it our communications. It supports everything basically. In time of peace, UNCLOS re-emphasize the rules or the obligations for states from the 1884 Cable Convention. And in times of war, we have some interesting things apparently. In Regulations Article 54, this is the main research question that I were underlining. That, well, we can see from Regulations Article 53 that the cable itself must be restored and compensation fixed when peace is made. That is already emphasizing the state responsibility. However, in Article 54, the SEC itself requires absolute necessity in order for us to seize or destroy it. This absolute necessity phrase become blurred because in the travaux préparatoires, or we can understand it like as the pre-conventional or the pre-treaties documents, we cannot find it anywhere in Regulations Article 54. So how does this going to affect the governance of the SEC in times of war? In San Remo Manual, the same thing again, and I will move to Tallinn Manual and also Manual because there are some legal blurriness in this. This is Oxford Manual, and this is a comprehensive review that gonna be answering the first research questions. So first of all, I found that the hard law applies in time of peace. The second, the soft law applies in times of war. And third, there's a legal vagueness in Article 54 of the Annex to the Hague Convention IV, which already been outdated, and it does not define the phrase in the case of absolute necessity. Side of that, I also found that the Rule 69 from the Oslo Manual, which considers the phrase qualifying as lawful targets, it is also not defined. So what are we gonna do with that? Also, the Rule 37 of the 1994 San Remo Manual does not prohibit the destruction of the SEC against fellow belligerent states because in IHL we have the neutrality principles, and it is more like inconsistent as well. And moving to Rule 101 of the Tallinn Manual 2.0, as I said in the beginning, that the status itself of the SEC is not yet had been defined. So it creates the gray legal status. Can we destroy as SEC in war? If it is actually considered as a military object, and if it actually considered as a civilian object, then we cannot destroy it at all. So Rule 101 argued that SEC, if it's actually maybe 10%, 20%, if it is actually used by military, then it is a military object. Therefore, this is the one that I've been criticizing because it gives a gray legal status in a very fragile world, in a very in this situation we need the SEC, but when a single act of a military object are going through that cable, then it is a military object. So it's gonna ruin all of the activities in the state. In chapter 4, I made a regulatory model for acts of damage or acts of destruction of the SEC itself. Well, what is the urgency? As I mentioned before, SEC is the key of military advantage. We can see the international geopolitical tension. It was Venezuela, it was the power of US, Russia, and NATO being bumped into one another, and also the accession of underwater drone. So what I propose here is that the Lex Lada, which mostly consists of soft law, is, well, it is effective and it is not taking a long time. Therefore, if we make a resolution to resolve these issues, then it can be a moral burden. Then I also concluded that the ambiguity of the limits of military necessity in the Lex Lata, namely in the Article 54, well, it should be interpreted in a human way. As I revert to the Liber Code in 1863, that military necessity should be defined as an effort that must be undertaken to win the war and in accordance with the applicable law. And we should also consider the morality and the public conscience itself, according to the Martin Clause. What is the Martin Clause? Martin Clause is the first part of the preamble of the Hague Convention itself. So it's more important to understand the preamble first, according to the VCLT, because the interpretation of the treaty should be referring to the Travaux Perpetuat. It should be referring to the principles and the preamble. And I was also identifying the legal loophole itself. The status of SEC in the view of IHL itself is now inconsistent. So we have to decide whether it is a military objective or whether it is a civilian object. Also, the Lex Lata is becoming increasingly irrelevant. What I've been proposing here is the declaration. So why declaration? In the case of nuclear weapon test case, the International Court of Justice in 1974 considers that when a state enters a declaration, according to the Pacta Sunt Servanda rules, or in the law of treaties, as we can see in the Vienna Convention, the interested states may take cognizance of unilateral declarations and place confidence in them, and are entitled to require that the obligation thus created be respected. So, well, if a state expresses that they want to be bound by something, they want to be bound by an obligation, then it is an obligation. The formulation of rules itself, I propose that the legal status of the SEC should be a civilian object, because when we put it as a military objective, it will cause it more harm than the good. And second, regarding the absolute necessity, we can also create a negative list or an absolute prohibition on the destruction of SEC only if the consequences are, first, the failure of national banking system, because we gotta be real right here. The national banking system, if it stopped, just imagine we don't have QRIS and we don't have any our debit cards working. Maybe some of you remember that we have to take our cash as fast as possible because there's gonna be electricity coming down, and also the SEC is not working because of the war. We already know that. So that's why I'm proposing that, we cannot destroy the SEC if it causes the failure of national banking system. Second, if it causes famine or civil unrest. And third, disruption of access to hospitals and humanitarian assistance, because these three are essentials and it should be there. And third, the physical distinctions of SKKL, namely, we have to mark the SEC itself, if it's damaged later by the AUV, it could instantly trigger the state responsibility because we have identified by colors. If the SEC, well, it's not going to be retroactive, right? But if we apply this formulation of rules in the future, then it could be helping a lot, because the principle of distinction itself is aimed to upholding humanity. And fourth, about the neutral states, we have to reaffirm the Rule 37 of the Submarine Manual, shifting from due regard to total prohibition. And five, regarding the sanctions itself, well, the previous laws might be and clearly mentioning about the compensation. However, the sanction itself, we could be more clear with them that we could have full reparation in the form of financial compensation covering all losses, dispute settlement through the ICJ, meaning that not only the destruction of cable itself, not only the compensation for the cable itself, but also the collateral damage that it been done, namely maybe the banking system has failed, they could compensate that as well. So there's some prospect and challenges. As you can see, that there are the urgency for reform and also the prospects. If this idea, if this declaration are approved by an absolute majority, it could lead to the evidence of opinio juris and also the legitimacy and stronger legal consequences. So what is opinio juris? Opinio juris is the belief of the state itself, because when we are talking about state practice, there's going to be two elements. The first one is opinio juris, or the belief of the state itself, and the second one is the state practice itself. So it's the act of the state. And what is the challenge? Yeah, as we know, we have Russia, we have the United States, we have China, we have some states that apparently treating international law like it's nothing. So it's going to be a political resistance from those 5 states, right? And that's going to be the challenge. But if the states are putting aside their interests, it will be very possible to prevent a bigger damage, to prevent a bigger losses on each state. So this is my conclusion, that I have been mentioned before. The phrase of "in the case of absolute necessity" is still vague. It creates an asymmetrical international armed conflict. It causes impunity to states as well. And well, as we can see that the current lex lata, the current law itself, is not ideal. So we can propose a reform from it. And the right regulatory model that I've been proposing itself is to address the legal ambiguity that I've been saying before, and also the clarification of absolute necessity, the standard of physical distinction through cable color coding, and the strict liability for AUV owners and full financial compensation. Those conclusion therefore creates a better state responsibility, a better concept of the tangible acts that a state could do in order to compensate every destruction of SEC. This is my recommendation for the ICRC, the UN, and the ISA, and also the ILC. And thank you for your time, for listening, and looking forward for the Q&As. I will give it back to Ibu Cha. Thank you very much, Ibu Cha.
Thank you very much, Vondra. Very fruitful and interesting, very amazing presentation. Thank you very much for your hard work. And before, let me give my greeting to Professor Ida Bagus Wiase. But before Prof. Wiase will give comment, what Vondra delivered today about submarine cables are very clinical infrastructure. So if that submarine cables being destroyed, it will affect many aspects to us. I think that's it. So how to protect it, maybe how the challenges, and Fondra even think forward about model regulations, and it's very amazing. So before the questions and answers, so I will give time for Professor Ide Bagus Wiyaso, so he will give his comment to event today. Professor, the time is yours.
Thank you very much, Ibu Chok. I would like to give you back the chance. Please deliver to the participants. I'm watching. I'm here.
Okay, thank you very much, Professor. So for all participants, you will maybe before question and answer, maybe Pak Budi as a co-supervisor, maybe there is comments for Fondra.
Thank you very much. Actually, it is the honor of the first supervisor, Professor Ide Bagide Palguna. So allow me to greet our senior, Professor Ide Bagus Wiyaso Putra, and once again, Profesor Ngurah Parikesit, Ibu Dr. Chok Istri Dihabudantari Pratnya, Bapak Putra Ariana, and all other colleagues, and also all students. I think I would like to express my great appreciations to Carmelita Fondra Wijaya. I think this is not question, just something that I would like to what the process behind that I could reveal is that since the very beginning when we conducted meeting, supervising meeting with Professor Palguna, Fondra, and myself, we firstly inquire the legal issues and then try to find relevant legal basis. And then we realize that there are several legally binding and non-legally binding documents that makes the research very interesting to be carried out. And what just presented by Indra, and she presented the Lex Lata, I think that's the comprehensive analysis on that. That the gray area is very interesting, not only for the Fondra research, but also to the upcoming researchers. I think the submarine cable still needs more technical aspect to be scrutinized by other researchers. But I think Fondra, you've made such a great research on that. I mean, I'm so proud with the result of the research. I think the examiners also during the final exam also have evidence how the great works were made was created by Fondra. Success for your future career, Fondra, and I will give back the time to facilitator Dr. Chokorde Istri. Thank you.
Thank you, Pak Budi. And if I'm not mistaken, allow me to greet. I think Fondra fathers join this meeting. Good evening, Bapak Ignatius Darta. You must be so proud of your daughter. She's very amazing. Thank you for joining us.
Thank you. You're welcome.
And of course, Prof. Parikesit maybe will give an comment for Fondra. Time is yours, Professor.
Okay, thank you so much, Ibu Dr. Istridiah Widiantari, for giving me the chance to talk, but I don't want to spend too much time for this session, but I would like to comment about how Fondra can make something important and crucial, but in the very down-to-earth way. So when we talk about, I believe that no one will in this situation, and no one will properly aware about the importance of submarine cable. But when Fondra make an example of the internet, then we are realizing how important, not many aspects, but almost all aspects of our life rely on the internet currently. And from the international law aspect, then there is some loopholes when the current existing international arrangement has not yet regulated what would happen if the submarine cable, when the world is so uncertain, so turbulent, then some parties, it doesn't have to be a country. It could be a belligerent to do that. It could be a dark company to do that. And when that happened, international law still leave any loophole. And Fondra has mentioned this issue and deliver some good recommendation. And it's supposed to be not just Indonesia concern, but also all the international community, because I can't imagine if the submarine cable, or let's say in Hormuz Sea, is really destroyed because of the war, and then it will impact the all connectivity across the globe. So I think that's all my comment, and thank you so much for giving me chance, Ibu Dr. Istridiah.
Thank you, Prof. Parikesit, for your comment. And the last, so allow me to greet Bapak Kolonel Lukas Meliala from TNI AL, also joining this evening session. Thank you very much, Bapak. Okay, now for all participants, I guess there are many questions from you. So now it's time for all their questions or comments. So you may raise your hand and unmute. Okay, for Lanina.
Okay, thank you for the opportunity. So my name is Lanina. It was an interesting topic, Kak Fondra. I was just really curious about, you already mentioned about an absolute necessity to do such this research and maybe make a new rules. But since as we all know, international law often lacks of enforcement. So what happens if maybe a very, very powerful state just ignores these new rules? And is there a way to actually hold them responsible, or maybe what would you suggest more, Kak Fondra? Thank you.
Okay, thank you for question, Alanina and Fondra. Maybe you can directly answer the questions.
Thank you very much, Ibu Cha, for this opportunity. And hi, Lanina, how have you been doing? I kind of see you on campus, though. You're a very smart person, and congratulations for the IHL, right? Yeah. So
Thank
yeah, that's a very great question. Thank you very much for joining as well. So starting from the absolute necessity, when it's made vague, when it's made blurred, and there is also the lack of enforcement, which is making it more worse, as we know. And let's say the USA ignores these new rules again. I have discussed this with also Prof. Biasa. He was in my thesis defense. He was the lecturers that helped me to discuss, to go through it, or what might be lacking from my thesis, because I know this is not perfect. This needs opinions, because I'm only like an LLB candidate and he's a professor. Imagine. So what he says, and what I've been agreeing as well in my revisions, I have also proposed a joint agreements for the states that have been wronged, the states that the cables, their SCCs are being destroyed in war. So what we could do next is we can make a joint agreement. So when the states, so it's basically, it's maybe we can resemble it to, what do you call it, when there is an environmental violation and all of the people are, suing the government, suing the company. So it's the same concept. So the states, we can also ask for their state responsibility. We can convince that state that actually, when there needs to be a reparation, there needs to be satisfaction, and there needs to be compensation for what they have been done wrongly, of course. So not only one state, but a collective actions for the states itself through an agreement, through a declaration. So this is actually happening in around 2024. We do have the New York Declaration that declares actually the SCC itself is an important object, but we do not have any declaration, any joint agreement that actually mentions that the SEC itself in war. How should we treat that, and what can we done in order to invoke the responsibility, in order to create and also the trigger the state responsibility, the compensation and all, so we can do it through a joint agreement.
Thank you, Kak Fondra.
How do you think, Nina?
It's quite maybe I understand that, but it just make me still unsure about how would it be an enforcement and something like that. See. Thank you, Kakak.
Yeah, sure. I get your point. This is a very interesting question, and I will dig down to the discussion itself, because international itself is a coordinative legal order, which means that if there's no consent, then there's no way we can enforce it, right? That's why my friends and my batch always say that, why don't you take international law? It's so ayam sayur. You cannot even enforce it. So some kind of that. But I do believe that, international stems from natural law, as you can see Thomas Aquinas and maybe some legal scholars that are in this view when there is a state sovereignty, it cannot be well, the state sovereignty itself, it's not it cannot be wavered. But what can be waived is the consent itself from the state. So we still need consent, we still need collective actions, and maybe the closest thing you can do is to embark, to create an economic sanction to the state, so they can do anything. So that's why you gotta learn about WTO. It's so important. What do you think, Nina? And if that's okay, Wucha?
Okay. Thank you for the question, and thank you for the answer for Fondra. And so another comments or questions from participants? Come on. Okay. I read in chat box. Wait. Okay. So there are question in chat box from Dian. So maybe Fondra also read the question. So who must take responsibility for a submarine cable that use for military? Oh, there are dual function maybe from Dian question. So how about the regulation if there are if damage occur from the situation? Maybe Fondra can give your response from Dian's questions.
Thank you very much, Wucha, for this question. And also, Dian, I cannot see your face. Come on. But it's okay. So I could understand where is this question actually leads to. So first of all, who is going to be responsible? Second of all, the law itself, yeah, it's still bad. As we can see, the Lex Lata, we can still evaluate it, and also we could propose a legal reform. And also, does the soft law itself could fix the Tallinn manual, Oslo manual, San Remo, and etc., because it's merely a soft law? Well, from the last question, the soft law itself looks like a real problem here, because it's not a hard law, there's no consent of the state, but what's actually make it enforceable and also tangible and also maybe binding, state itself showing their interest or showing their expression that they are out to be bound to a declaration, then it is, according to the nuclear test case in 1974, it is an obligation. It creates a moral obligation from it. So it is still an obligation that the state should also consider and recognize. However, when a declaration is made, when it was born, then it is not instantly making the whole thing an obligation. It is not making the consent, the rules itself instantly binding. No, it becomes then an customary international law that should be obliged by the states itself, as we can see in the ICJ statute article 38, that we recognize what are laws, what are international laws, what are the sources. Those are treaties, customary international laws, and then we have teachings of the legal scholars and blah blah blah. We have the cases also, as well. So well, it might be still controversial for us to say that, oh, well, soft law is 100% working. No, we cannot say that, but we can guarantee that actually the soft law itself, it creates a moral obligation that slowly creates a customary international law. And moving to who's going to be responsible then? This is a very great question because as far as I remember, Bapak Dr. Ida Bagus Erwin asked me as well in my thesis defense, but that's not the case. First of all, we gotta decide whether this is a military or whether this is civilian object. If that's a military object, then it would be justifiable to destroy them. But then if it's a civilian object, we cannot destroy them. Who is going to be responsible if the military objects are being destroyed? Then it is on the belligerent states. But if the civilian objects are being destroyed, then it is, of course, also the belligerent states violating the international humanitarian law. So there will be no way when a state destroying this submarine communication cables with the proposed negative list, as I said before, the banking fails and humanitarian assistance cannot go to our states, and many more. There's chaos, riots. Then what are we gonna do with that? The belligerent states should be responsible. And the way to create that circumstances to make it ideal, therefore we have to reform the law first. So your questions are very, very good. It creates the structure of the logical thinking, where is research going. And thank you very much for the wonderful question, Diane. What batch are you in, by the way? What batch are you in? Are you 2024, 25?
No, angkatan
really?
2019.
Oh my God, Kakak, I'm sorry.
It's okay, it's okay.
Thank
It's
you
okay,
very much,
it's okay.
Kakak. Yeah, thank you very much, Kakak, for joining. I'm sorry for calling your name without Kakak. I didn't know you. Sorry.
It's okay, it's okay.
Sorry.
Just okay, just okay.
Sukses, Kakak.
Okay.
Maybe that is Bucak.
Thank you for the question from Dian, and also thank you for the response from Fondra. And before we continue, let me allow me to greet Professor Ideo Gedit Alguna that join us this evening. Good evening, Professor.
Good evening.
Maybe Professor would like to give any comment for Fondra, maybe?
Yeah, thank you very much, Bucok. I'm sorry for being late because there are some problems. Not a problem actually, but I have an inevitable appointment with two of our former students, and there is a hot discussion among us. So it caused me late to join the discussion, the interesting discussions. As you know, that Fondra, I was one of her supervisors, and I'm very grateful that Fondra managed to defend and to dig deeper into the problem with a wider, with a so wide insight and so wide analysis and sharp as well. So I think all the examiners had given her 2 thumbs ups for the presentation and for the substance of her bachelor degree skripsi or thesis. But tonight we can see how deep her insight, how deep her analysis, and how well prepared, she carry on her duty or her obligation in delivering the what is, I should say, the so vital issues, especially when considering the latest development in our international realm, especially what happened between the United States of America and the Republic Islam Iran and Israel on the other side. But that's another story. I would like again to say thank you to Fondra for for your very great presentation and for your best performance, either when you defend your thesis and for your presentation tonight. Again, I'm sorry. I'm so grateful. 2 thumbs up for you. Thank you, Buchok. Yeah.
Thank you, Professor Palguna. And we still have time, about 20 minutes. So if there are any other comments or questions, you may use the time. For all participants, if you still have questions.
Maybe I would like to ask Fondra's opinion, Buchok. May I?
Of course.
Yeah. Fondra, suppose that today, when we see the confrontation, I should say illegal confrontation between United States of America and the Islamic Republic of Iran and Israel on the other side. What do you think? It is still important to study international law, especially international humanitarian law, because there is an old saying in Latin phrase, inter arma silent leges. You know that, yeah. Well, inter arma silent leges in bahasa Indonesia, ya. Ketika perang terjadi, maka hukum diam. Inter arma silent leges. So I would like to ask your opinion, your insights as to whether it is still important to study international law, especially international humanitarian law, which is closely related to your legal issues in your scripts in your undergraduate thesis. Thank you.
So, Fondra, you may answer what Professor asked about this.
Thank you very much, Buchok. And Prof. Palguna, thank you very much for the speech. I'm kind of nervous.
No. Please be good.
So, yeah, regarding the importance itself of studying IHL in the midst of the adagium, inter arma, and also Silanege, and also the existence of the illegal confrontation between USA, Iran, and Israel. I would like to share my personal insight on this because once I kind of have the crisis that am I doing the right thing? Am I studying international law for fun? Or it's just like I am tired like people say it. But apparently I was thinking because the IHL itself, as Pietro Fieri says in 1992, he made the whole IHL manual, and the aim of the international humanitarian law itself, it's to defend the humanity. It is to the essence of humanity, and therefore, I don't think the law itself has ceased fully. So it's still there. It's still there, and it's still defending the rights of the people that actually doesn't have anything to do with the states itself. When we are talking about the war, actually, I saw quite a lot of films. Yeah, the one that I've mentioned before, Hacksaw Ridge and 1913, and I can name more. But the thing that always touches my heart when I see those films, it's not about it's not about who wins the war, but who has the more fallen soldiers. How is it? Yeah, how is it look like actually in the war, and how is it very horrible to see people died and they're getting wounded, and what if the law is really died, it is really silent, then there will be no ICRC, there will be no Geneva Conventions. I think the studying itself, studying international humanitarian law itself is still very important, regardless that we are shifting to a more technological warfare without sending our soldiers to the to the field itself. It's a whole different story, because the humanity is still there. So it is still important to defend it. Although it's maybe in the field itself, it doesn't seem so. The humanitarian assistance does not even reach the civilians, and many problems, many challenges are existing until this time. But I do believe it is still important. It comes from natural law. It comes from God, and it has a different legal. How can I say this? It has a different legal standards than just a consent, than just a private law, maybe a civil law or a criminal law. It has a different level. So I would say it is still important to defend our humanity. Thank you, Prof.
Yeah. Do you agree if I say that, or do you agree with the standing who says that by studying international law and studying especially international humanitarian law, actually we are defending our humanity? Do you agree with this statement?
I do agree, Prof. For IHL, not for not for the lex generally, not for the whole international law, but I do believe that every law, every branches of law, may it be the trade law, maybe it environmental law, it's for the good for the people, as Roscoe says, and yeah, tools of social engineering, it's still there, but we have to be aware that actually international law comes from natural law, that therefore human rights, existence, humanity, it comes from something that we have to dig deeper. We have to look at it wisely, and it's not a law, black and white laws. It's not, but it needs to involve our heart. It needs to involve, if in Indonesian I can say, it involves rasa in everyone. Thank you, Prof.
And science. Okay. Okay, Bu Chok. I'll back to you, Bu Chok. Now.
Thank you. Thank you, Prof. Palguna, and thank you, Fondra, for the comments. Maybe I will give time for Bapak Lukas Meliala from TNI Angkatan Laut. Maybe there is comment or insight for us here about what happened today.
Yeah.
Thank you, Bapak. The time is yours.
Good evening, Bapak dan Ibu sekalian. Can you hear my voice?
Good evening.
Okay. Very clear.
Yes, very clear.
Thank you. Actually, I don't know how to start it. So many questions in my mind, Fondra. But first of all, I want to congratulate you, Fondra, for your achievement. I'm really proud for it. And then my question is very simple. Fondra, are you ready to be advocating humanity? Are you ready to be advocate for any humanitarian case in the future? That's the question. Thank you.
Thank you, Bapak. Fondra, you may respond directly.
First of all, Bapak Kolonel Lukas, thank you very much. It's such an honor to have you here. You're my inspiration when when I started my internship at Polcom. Thank you very much for discussions and exchanges. For your question, of course, I am ready, fully ready to advocating humanity and also any kinds of humanitarian assistance. And I hope this research can also contribute to our country, because I see that this is a very political. This is, well, it's just a cable. It's not bigger than a garden hose, of course, but this is a power. There is power in this cable. There is political interest from every states that went through it. It's not about the data, but it's about lives. It's about saving the existence of a state even. So I could say I'm fully ready to help. Thank you so much, Bapak Lukas.
Good. It's good.
Thank you, Fondra. So is there any questions or comments left from the participants? So everyone satisfied? So before we finish this session, so about what Fondra delivered from her research today about cable submarine, we already know in modern warfare increasingly depends on information, communications, and digital infrastructure. Submarine cables have become vital strategic assets. Their protection is therefore important not only for national security, but also for global stability and civilian life, of course. Not only just a cables, but it's a vital assets for us. So thank you very much. And once again, let me appreciate Fondra for what she had done for her research. I hope it will be inspirations to other, and also it will be beneficial for not only for Fondra, but not only for Fondra and Fakultas Hukum Universitas Dayana, but for Indonesia, of course, and for thank you very much, and also for Profesor Dewa Gede Palguna, Profesor Ida Baguswiasa, Bapak Dr. Budi Arsike, Profesor Parikesit, Bapak Putra Aryana, and Bapak Kolonel Lukas Meliala, and Bapak Ignatius Darta, SYL, And all the participants, thank you very much for joining these events. And I give back the time for Belinda, our beautiful MC for today, our beautiful host. Thank you very much, Belinda.
Okay, thank you to Ibu Chokdia, Miss Fonra, distinguished guests, and all the participants for the awesome discussion session. We really appreciate your dedication to make this dialogue more meaningful. Before we proceed to today's closing session, we kindly ask all participants to fill out the final attendance link that will be shared in the chat box. Okay, now I would like to invite all participants to turn on the cameras as we begin the documentation session. Okay. Starting in 1, 2, 3. Once more. 3, 2, 1. Okay, thank you.
Yep.
As we conclude today's session, I would like to express my sincere gratitude to everyone for your valuable contributions to today's discussion. Please ensure you complete the attendance form to obtain the certificate. On behalf of the organizing committee, thank you for your active participation. We look forward to seeing you again at our future events. Om Shanti 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 Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, and may peace be upon all of us.